Joining me now, Justice Santosh Hegde, former Supreme Court judge, joins me. Justice Hegde, this is a major order of the Supreme Court. How do you interpret it when it speaks about the constitutionality of the Enforcement Directorate's powers under the Prevention of Money Laundering Act? The court seems to suggest, Justice Hegde, there is nothing about the law that is unconstitutional, that the ED does not even need to be treated like a police authority that comes under the Criminal Procedure Court. Burden of proof on the accused. Do you believe this is the right approach that the court has taken, Justice Hegde, or are they giving excessive powers to one agency now?
According to me, the view is correct. There is nothing wrong with the view, taking into consideration the nature of offence involved in it. This is an act which prevents the use of any monetary consideration received in a crime. That itself is an offence, and if by utilizing that money or using it in any manner or participating in a crime which receives such money is an offence under the PMLA Act. That is Prevention of Money Laundering Act. Here is a case where a person utilizes the cash benefit he receives through himself directly or through some other source from a crime. He is being investigated by the Enforcement Directorate, who have been given certain special powers. It's unlike the most other crimes and all. This is something of much more severe consequences on the economy of the country. Apart from being, it is a product of crime, it is also avoiding taxation and in a manner encourages hoarding of money. Therefore, I think there are certain liberties should be given to the investigating agency. After all, what is the liberty given? One is to investigate without filing an FIR. That, according to me, does not violate the Article 21 or any other right of a person. So, of course, burden of proof is a matter which is to be decided on the nature of crime. Therefore, I don't think the Supreme Court judgment is in any way wrong.
So you're saying that you believe that this judgment in a way affirms the constitutionality of the Prevention of Money Laundering Act and the powers bequeathed to the Enforcement Directorate. But there will be those, Justice Hegde, who will argue that only last week another bench of the same Supreme Court warned against India turning into a police state, warned against arbitrary arrests, warned against the process being the punishment. Now we are giving excess powers, some would say, to the Enforcement Directorate to act against the so-called guilty, and that could lead to even more such cases of the process being the punishment.
Look, it is not the Supreme Court which has given them the ED the power to investigate, unlike other crimes and all. Look, let us look into the nature of the crime. Here we are dealing with benefit a person acquires from a crime, which will be separately dealt with. Now, so far as the person who comes under the investigation of the Enforcement Directorate is a person who receives the cash benefits or any material benefits which arises as a profit from a crime. Now, who knows more about it than the person who collects the money, from which source it has come, from which crime it has come? So far as it is not declared, then the ED gets the power to investigate even without registering an FIR, which is a statute. And this statute is not made by the Supreme Court, the statute is made by the legislature, whichever party which was in power at that point of time. Therefore, even the burden of proof, according to me, because of the facts of the case, unlike, let me take a case of murder. In a case of murder, it is clear that it is for the prosecution to prove beyond reasonable doubt a crime has occurred. Yeah, but then the information in the source of investigation will clearly show what is the participation of the accused in that. Here is a crime where a person receives certain money through underhand dealings and all by the different sources, which only the person who receives and the person sends has information about that. It is extremely difficult for the investigating agencies to find your own. Normally it won't come to the bank transactions, and even where there is a accounting fraud and all, it is extremely difficult to find out. But a person who has the money in its possession definitely knows from which source it has come. That is why the Supreme Court must have come to the conclusion the burden of proof also lies on the person, provided of course the investigating agency proves that he was in possession of certain amount of money which is unaccounted.
Right.
Therefore, that is not a this burden that's under Article 21, nor with the right of the ED to investigate.
Sir, you're saying therefore right to life and liberty, Article 21 is not affected by these powers. But when I look at the data, the number of offences being registered under the PMLA has increased manifold over the last 5 years. But the conviction rate remains very low, barely 0.5% conviction rate. Should that not be a worry? You're arming an agency with all these powers, the court is validating it, while the conviction rate remains low. This leads to the fear that the process can be the punishment and these powers can be used to settle scores, and it doesn't lead to conviction.
Look, Mr. Sardesai, if you look at the percentage of conviction in anti-corruption cases, also it's hardly 27%. But do you think in our country corruption has reduced? Or people involved in the corruption, their number has gone down? I do not know what's happening in the courts. Maybe the manner of investigation is so poor because people involved are so powerful that they are not getting conviction at all. But that definitely does not mean mere percentage of conviction leads to the conclusion that the investigating agencies either being partisan or frivolously filing the criminal complaints. And I'm sure if the courts are honest enough, they will come down heavily on matters which is a false case.
No, but this concern, sir, the concern over investigations turning out to be partisan, that is one of the criticisms, that the ED now is using the PMLA, much like during Indira Gandhi's time, some of these laws like Misa Coffee Posa was used, some say, to settle political scores. The charge is the ED will use PMLA to settle political scores on behalf of the central government. Only opposition members of the government will get trapped in PMLA cases. Is that a valid criticism or not?
Well, Mr. Sardesai, this is an allegation which always comes from the opposition party. I am not saying that the ruling party has been very fair to the opposition and they have been investigating their own people in the culprits in their business. No, they have not been doing it so. But that has been what has been happening when any other party was in power also. They only attack the opposition. But Article 14 of discrimination does not apply in criminal cases. Of course, when they come to power, they'll do the same thing. That doesn't mean I won't do it against my own people, that I won't be doing it against you also. That is the equality doesn't apply that way.
No, sir, but the point...
Let the court decide whether it's right, and in a false case, the court should come heavily on the prosecution.
In a false case, the court must come heavily against the prosecution. Are you saying that's the check and balance in the system? Do you believe that there are certain checks and balances other than that that could be brought in to avoid any potential abuse of power by this one agency, the Enforcement Directorate?
Well, I think that should be left to the investigating agency's honesty in the thing. If they are playing to the tune of their masters, they certainly should become brought into books by the courts, but not by a person who is accused of the crime. Because everybody can say, I belong to a political party which is not in power, therefore I am being prosecuted. That's exactly what is happening now. I'm not talking about whether there is prima facie case or not, because I'm not judging the matter, I don't have the material in it. But generally, every case filed against the political party which is not in power today are being defended on the ground it is a malicious prosecution. Let the court decide it, but don't prevent the matter from going to court. I know when they come back to power, they will do the same thing in regard to the party which is in power today, and they should do it. According to me, they should do it to everybody. But even if they're assuming, for argument's sake, they are partisan, then that is no ground to say that malicious prosecuting, false prosecution should be brought down heavily by the courts. But that can't be decided by the accused. You can't say merely because I'm the leader of an opposition party, I'm being harassed. Let the court decide it. Why can't how the people in the streets decide this, whether it's guilty or not? If that is done tomorrow, justice will be delivered in the streets. What I say is correct, then that has to be settled.
You know, the question therefore is that, is the judiciary non-partisan enough? Can it ensure action is taken against malicious prosecution if it is undertaken by an agency like the ED that now, as I said, has such wide-ranging powers, sir?
Well, I won't guarantee you that, but that doesn't mean the system is wrong. But people who are investigating the system or in the judicial side of it are not doing justice. You can't blame, that means everybody will say that no case under the ED against an opposition leader should be filed at all, because that's the defense. Let the matter go to court, and in our system we presume that the judiciary is independent and is not controlled by a political party. Therefore let them decide. Maybe that's the reason there's large number of acquittals are there.
Right. Can I?
But you can't decide it in the streets. I see it now. A party which is in power at the center today says the same thing when it comes to Andhra Pradesh, when it comes to West Bengal, when it comes to Tamil Nadu, they say the same thing, we are being persecuted. But they don't realize their own people are involved. And it's a known fact. I have seen in 5 years of my experience as Karnataka Lokayukta what corruption is. It has no religion, it has no political party, it has only one motive, that I must make money during my office.
Very, very strong words coming from you, Justice Hegde. I hope our political class is watching or listening. I must add though that since you mentioned Karnataka, sir, today it has a BJP government and the accusation is therefore there is no ED action taken while all the action focuses on the opposition ruled states from Bengal to Tamil Nadu.
But that can't stop investigation. That can't be an example for striking down investigations. No, that can be done only by courts.
Justice Hegde, always a pleasure talking to you. Nice to see you looking fit and well. Thank you so much for joining us.